Hello everyone, I'm Trisha Parasar and I'll be teaching you jurisprudence today. Not teaching, basically just discussing about it because this is going to be the first question paper that you're going to receive from Faculty of Law. So yes, let's get started. The very first topic in your case maths, and I think the case maths are brilliant, like just aside from the topic. Case math is a brilliant source for reading and preparing for jurisprudence, although you may refer to books like Entrangepe and things, but this will suffice for sure. Alright. Okay. So the very first article is, as you can see, major legal systems in the world today. Alright. Now, one thing we need to understand is that although the article says it is today, it talks about the different, different legal systems that helped evolve the contemporary systems that are prevalent today. All right, it actually doesn't talk about the contemporary legal systems of the world. It talks about the ancient ones who helped us in evolving our present, and when we say our, I mean the world, not Indian. All right, so it helped us evolving our the kind of legal system that we see today in the world. All right, okay, so Artemis, you can go back to the aquarium because I'm shooting. So yeah, one thing is, so there are basically three basic legal systems of the world. One being Romano-Germanic. Okay, let's come to my notes. One being Romano-Germanic. Okay, the second one being the common law family, and the third one being, it is on the next page, family of socialist laws. All right, so let's get started. Romano-Germanic family is the first family that ever came. All right. It includes those families in which legal science has developed based on jus civile. Now, jus civile is a maxim meaning justice among civilians. All right, and what else? Now, one thing we need to keep on mind is that it did not evolve. It is not based on this maxim. It is based and it is founded on the principles, okay, which are based on this maxim. Now that is a different thing, like these are two different things. I hope you understand. Okay, there are some principles that are based on this, and on those principles, this is, I mean, on those principles this family has been founded. When we go deeper, we come to the next point and we see that every legal system has what do we say, a principle, a rule of law, okay, a very significant feature of its own. Okay, one thing about a Romano-Germanic family is the rule of law here kind of monitors conduct of the subjects. Okay, in a sense it guides the conduct. Okay, now the conduct is closely linked with the ideas of justice and morality. All right, now what does that mean? When we talk about so every legal system has a specific principle. Okay, and the specific principle of this family, Romano-Germanic family, is that the rule of law over here, it is conceived as basically rule of conduct, okay, that are intimately linked with the ideas of justice and morality. All right, what does that mean? Now the purpose of this family was basically to monitor the private relationships of the people. This emerged in a very peaceful time. This kind of family, it evolved during a very, very peaceful time, and the sole purpose of this legal system was to maintain that particular peace and harmony. All right, so why do we need the law when everything is harmoniously going on? the only need that can be is to maintain that thing. So yeah, the rule of law was intimately linked with the conduct, and then they were intimately, the rule of conduct was again intimately linked with the ideas of justice and morality. Okay, coming to the scholars, now obviously when we have studied कि भैया इसका जो major principle था वो यही था कि लोगों के conduct को maintain करना, लोगों का conduct बना रहे, एक harmonious environment रहे. So but obvious that is something like you don't need a Sherlock Holmes mind to infer that scholars were less concerned with the practical application. Okay, and why was that? Because they thought that bringing on a legal system, formulating the idea is a different thing, and the practical application, it depends on the administrators, lawyers and executors of the country, okay, and not them. So according to them, they did their job and they did it well. All right, coming to the evolution, now how did it evolve, like what was the nature of it? Not evolution, basically in what nature did it happen to evolve? It evolved as a private law. Again, I would say like this is something very, very basic, because the idea was to maintain, to monitor the conduct of the people, okay, the conduct of the subjects living in a locality. All right, so it was more of a private law. All right, one of the most important features of this family is coming of it as codes. Now these codes were, framed and formulated after and in 19th century. Okay, so like most of the ideas from this legal system came to be binded, framed, formulated, whatever word you want to use, in as like codes. Okay, there were specific acts, just like Indian Penal Code maybe. Yeah, it originated in Europe. Now this is the geographical region where it originated. Okay, so it originated in Europe. Okay, now what were the foundations of the what were the foundations of Romano-Germanic family? Okay, now the foundations were that it was based on, and it solely owes its birth to the scholarly efforts of the Germanic and Latin universities, and that is why we name it Romano-Germanic family. Like a lot of scholars slugged their asses, did their research and came up with this idea. Okay, so and that is why we name it Romano-Germanic family. All right, okay, now you know what, like scholars were not very famous then. It takes a lot to be a scholar, so apparently we'll have to name it, and we'll have to give some emperor a credit. In this case it is Emperor Justinian. Now Emperor Justinian, before 12th century, what he did was he formulated some of the ideas to just monitor, like not basically laws like as we see it today, but Emperor Justinian in this time period, okay, before 12th century, what he did was he framed and formulated some of the codes and acts, you can say. All right, and then on this the scholars did research, and then like again that is how we got Romano-Germanic family. All right, the next point, which is a very important point, is that how do we know that, like how did it spread actually, like how are we still reading it, and how is it in a syllabus for 20 bloody marks? So yeah, so one thing that led to its spread was voluntary reception. In the absence of a law, when you don't have anything, beggars are not choosers, they got something like this, okay, which monitored the conduct at least, and which maintained the private relationship of the people. All right, so what happened was people voluntarily received it, okay, and then eventually who doesn't have this? Like there was a need for modernization, a need to westernize, okay, and that thing that, you know, we should be modern, all right, we should adopt the ideas of the Western. So this feeling, this surge that went on, it helped in spreading of this particular legal system, all right. Okay, one thing that is very important at the end, like when you study, like there was voluntary reception, there was need for modernization among different countries, okay, countries like India and other Muslim countries, all right. But then from a sociological point of view, if we see the laws that were adopted, okay, we agree that they were adopted from this particular family. But if you see from this perspective, they have their own additions, okay, plus their own alterations, all right. All right, so before we go on to common law family, which is the second system, to give a quick recap, we have summed it in 11 points, okay. It was the first ever family, okay, that came up as a legal system, all right, and then it is founded from the legal sciences, which were based on the maxim jus civile, which means like justice among the civilians, all right. And it was more of a private law, and the rule of law, it usually monitors the conduct of the people, which are intimately linked with the ideas of justice and morality. Now the scholars who framed it, who formulated it, were, you know, they were less concerned with the practical application of it. And in 19th century, we see a distinguished feature of like them being formulated and framed in codes, all right. It originated in Europe, and it owes its birth to, you know, scholarly efforts of people from Germanic and Latin universities, all right. Also to this man called Emperor Justinian, all right. And then how it spread. Okay, so coming on to the common law family, obviously it forms the second family, and it includes the law of England, okay, and also the laws that are modeled on the English law, all right. Now it was formed primarily by judges. Now what kind of judges? Okay, who had their role in resolving the disputes, all right. Now the objective, now obviously if a legal system is focused on resolving a dispute, that means its sole objective is to give solutions, okay, all right. And not to, like, unlike Romano-Germanic family, we see that its objective was to monitor the conduct, okay, to establish a standard for, you know, how private relationships should be. Unlike that, it just gives, like, it resolves dispute quickly and it gives you the solutions, okay. So the nature of it is a public law, all right. Common law family is a public law, all right. And how did it spread? It spread through two ways. Now, but obviously we are talking about England, how can we forget the word colonization? We really can't. I mean, anybody wouldn't, especially, I mean, being Indians. So colonization was one thing. The other thing that led to its spread was the voluntary reception. And as far as, you know, the application, the perspective on reception is concerned, it is the same as Romano-Germanic family, like as in the countries who adopted the common law system, they actually did their own additions as well as they did their own alterations suited to their social atmosphere, all right. Coming on to the very third legal system of the world, okay, family of socialist laws, all right. Now this is the third most significant family. And now who were the members of socialist family? Okay, bingo, there's a fun fact. People who initially belonged to Romano-Germanic family actually transferred themselves to socialist family. Then why is it like it is very confusing, I know. Why is it there that we are reading it separately, and what is the difference? How do we distinguish between the two? Okay, now people who were initially in this category, they went on to form this family, all right, socialist family. Now what is the difference is that most of the time the legal rule, the terminology is used, the vocabulary of both the families are almost the same, but the differences is that they are more detached from let me shift to your case mat. I make short notes. I'm not more of a writing person, but just a tip that you should write before you appear in the exam. It just helps you. Like most people don't do that. All right. So wait, let me just find it for you. Okay, it's just the twisted words that I find. Okay, this is detached from RGF. Okay, and why is it detached? Why do we say that these people went on to form a separate family? Okay, a distinguished family. Okay, because of the origin. This evolved in a very peaceful time. All right, things were going well. To maintain it, to retain the position, peace and prosperity, it evolved. However, the source of this legal system was majorly revolutionary legislative works. Okay, so there is no doubt that ekdam krantikari jo hote hain, something like 377 is legal. Okay, so as revolutionary as that, it was based on such laws. All right. Now it is not static in character, all right. Now, like Romano-Germanic family was all about maintaining peace and prosperity, and you should behave morally, and it actually guided the behavior. It actually laid laws for how you should behave. It was more conduct centered. However, this was nothing is revolutionary. It has to be dynamic, and it aimed at overturning the society. All right, overturning the society as in there should be benefit of all, nobody should be neglected. All right, and majorly aimed at equality and things. Okay, now the source of this kind of why do I say this kind of this family is revolutionary work of legislature plus the ideas that expressed popular will. Okay, and then these were narrowly guided by communist parties. All right, now the area in which it originated was in USSR. All right, and after the 1917 revolution, the family of socialist laws was terrifically prevalent. Like they were existent over there, they were followed, and they were literally like it was the Bible of the people. All right, now one thing we come to is again it emerged in USSR. Okay, but however one should know the difference between the Soviet law and the socialist law. Let's give it a look. Soviet law is basically where RGF can be like RGF has a substantial contribution in Soviet laws. Socialist on the other hand is very revolutionary, and it is mostly in practice in the Far East states. All right, so yeah, that is it. Please like, subscribe. Okay, like at least subscribe for the spirit that I have. No camera, nothing, and still I'm doing it for you. And going back to such lengthy articles and preparing the notes, I think it deserves a big fat thumbs up. So yeah, and do comment how you find it. And yes, this is it for today, and I'll see you in the next video if you tell me in the comments below, like in the comment section. I'm not very good at drawing, that is why I chose law, by the way. Okay, so do comment that what are the videos that you want. Do comment and let me know if it was very helpful. Even if it was helpful to some extent, just giving an overview, it served the purpose. All right, so that is it. See you. Bye.